Now let us discuss the second part of contract, that is otherwise called special contract. So under this, the first thing we will discuss contract of indemnity and contract of guarantee. What is called, first let us discuss what is called indemnity. These things are specified from section 124 to 127 of Indian Contract Act. Contract of indemnity. Indemnity means somebody is taking risk of another. That means in case of insurance contract, fire insurance contract, the insurance company being the insurer is taking the risk to indemnify any loss that will be sustained by the person who has taken the insurance. He is called insured, and the insurer is the company, and the party who has taken the policy is called insured. So whatever the risk the insurer is taking for insurer for insured, so that type of risk, that is otherwise called indemnity. So indemnity is taking risk of one party by the other under certain terms of contract. What is the term? He has to pay that premium. Once the premium is paid, so contract is entered into, come into operation. This is based on section 124 to up to 147 discuss relating to theory of indemnity. In case of indemnity, two parties are coming into picture. First is called indemnifier, second is called indemnity holder. Indemnifier means the insurance company who is indemnifying the other party is called indemnifier, and the indemnity holder, that means the owner of the party who is taking the insurance, is called indemnity holder. That means the indemnity holder will be indemnified by the indemnifier. So that is the principle of this contract, the contract of indemnity. Now let us discuss what is called guarantee. Guarantee means any assurance given by one person for default of another, that type of guarantee. In case of something, in case criminal law, once a person is going on bail, somebody is standing as a guarantor or somebody is standing as a surety. So surety is also one kind of guarantee. In case of this contractual obligations or contracts, so one person is standing as a guarantee for other. In case of bank finance or bank loans, for the person who is availing the loan, some guarantors are there. Either some persons will be as a guarantor or some property will be mortgaged. That is called collateral security. So in this case, certain guarantee are coming into picture. So that is called contract of guarantee. So assurance given by one person for the default of another, because the other person has availed certain loan. That's why one party is giving assurance to the principal that in case of default, I will take the responsibility. That is called insurance of guarantee. So both the terms indemnity and guarantee are collateral with each other. So contract of guarantee, that means there is a guarantee and that assurance given by somebody by virtue of there is a contractual terms and conditions. So it is one kind of also obligations. So now let us say surety. What is called surety? Surety is also one kind of called guarantee. So by whom the surety is given? He is giving a surety to the creditor. So in case of surety, there are three parties are coming into picture. First is called principal debtor. The person who has availed the loan is called principal debtor. And in case of his default, the different parties are coming into picture. So in this case, so the two parties are there, mainly the person who is availing the loan. In case of his default, the guarantor will be held responsible. So there is called principle of guarantee. So this indemnity and guarantee both are linked with each other. Now let us discuss what is the basic difference between these two terms, indemnity and guarantee. So in case of this indemnity, one person's this insurer is giving indemnity to the other. That means on the happening of any collateral event or anything happen in future, in case of any exigency, he is taking a risk. But in case of guarantee, he is giving a guarantee that in case of any sort of default, he will be held responsible. First of all, the money will be recovered from the principal debtor. Once he failed to discharge the debt or he failed to repay the same, then only the picture of this guarantor or guarantee comes. So these things are indemnity and guarantee, both are interlinked with each other. Now let us come to another special type of contract, that is called chapter of bailment and pledge. Bailment and pledge, these are all specifically mentioned from section 148 up to section 181 of Contract Act. So bailment means, sir, there are two parties. bearer and belly. So here bearer means any person who delivers good to the in the possession of another is called belly. Suppose somebody is giving a watch for repair. The person who is giving the watch for repair is called bearer, and the mechanic or the workshop where he is giving the watch for repair is called belly. So there is a relationship exists between the bearer and belly in case of all bailment. So bearer and belly, so they are collateral with each other. There once something is delivered, that property must be a movable property. Once that is delivered, so a relationship is created between the bearer and belly. So certain once there is a relation is created, definitely both the parties are having certain rights towards each other. Similarly, both the parties are having duties to collateral with each other. So we will discuss now rights against third party first. What are the rights available to third party? So that rights against the third party is also called subrogation. In case of this bailment, if something is given by the bearer to the belly, at that time a third party, if he is having a right to sue, so that is called, in case of if third party is affected by this bailment, he can also sue. So outsider can also, a stranger can, outsider can also sue in case of this bailment. So that is called, so that type of capacity to sue is called theory of subrogation. So this is very much explained in case of this bailment chapter. So if any third party causes loss for this to the bearer or bellies, in that case he is having option to file a case. So the bearer can also sue the third party. Any loss that is attributed by the third party, the bearer has got option to file a suit. So that is based on the theory of subrogation. So this is relating to bailment and pledge. So here certain responsibilities are there, and some, what is the responsibility? The bearer, in which condition he has given the property or the goods to the other party, the belly, accordingly it is his duty to take utmost care, and accordingly he has to do the job. After that, finishing the job, he has to return. So there is a term and conditions contract entered into the between the parties, that is called, it may be implied contract, sometimes it is also express contract, but in many cases it is coming under implied contract. Now we will discuss another very important chapter, pledge. Pledge is given under section 172 of our Indian contract. It is also otherwise called pawn. Pawn and pledge, in some places it is used as a pawn, but in the term is called pledge. Pledge means any goods are bailed out as a security for payment, that is called pledge. Any goods, somebody, let us say somebody giving certain gold and availing certain loan from any financial company, so that is called pledge. The golds are pledged to the finance company for availing loan. So this type of this, some giving some property is bailed, and in lieu of that, some, because some security is taken for that payment of that security that is given, that is called pledge. So pledge is also one kind of giving a movable article before somebody for availing certain loan or money. So that is called pledge. So now we will discuss another chapter, that is called theory of hypothecation. Hypothecation means somebody is buying a movable vehicle. Suppose a person is purchasing a car. Once somebody is financing that vehicle, so the law of hypothecation comes into picture. So the real person, the real owner of the vehicle at that time is that finance company, and the person who is buying the goods is just like a caretaker. So at that time it will be said that once the vehicle is financed by some financer, it will be said that the vehicle is hypothecated to that company which has financed the vehicle. So theory of hypothecation come into operation. In this case, so hypothecation is also one kind of, the vehicle is provided or given to the owner, the artificial owner, but the ownership still lies with the finance. So that is called hypothecation. So basically the pledge and hypothecations are looks like same, but basically there is slight difference between these two. So now let us discuss what are the basic points basing on which both the things, pledge and hypothecations, are categorized or separated from each other. The hypothecation is also one kind of mortgage of movable goods. So now let us say first is pledge. In case of pledge, delivery of property is there. In case of pledge, some property is delivered for availing that loan. But in case here, there is no delivery of any property. In case of hypothecation, there is no question of any delivery of property. So that is the first basic difference between pledge and hypothecation. In case the pledge, second point is property in possession of pledgee. The person who is to whom the property is given is called pledgee. The person who is giving the property on pledge is called pledger. So the pledgee is in the possession of the property. But in case of this hypothecation, property is not in possession of the hypothecator. That means the person, sorry, the hypothecatee, the person who is possessing the hypothecation is issued for the property is called hypothecatee. So here hypothecatee or means the financier is not in real possession of the property, but the property is in possession of the person who has availed the loan. So the person on whose name the RC book is there, he is plying the vehicle and he is in possession. So the property is never in possession of the hypothecatee. So that is the basic difference. Third is the pledge is one kind of genus, we can say. From this genus, this pledge is developed. Once it is a genus, so definitely the hypothecation is a species. So species is a branch of this pledge. So hypothecation and pledge both are distinguished in this way. So pledge is definitely a pledging some movable articles for whatever the loan that has been availed. But in case of this, the ownership of this article is still with the financier in case of hypothecation, but the party who is possessing the vehicle is some other person, and for that there is a contractual relation between the financier and the person who is availing the loan. So that is called hypothecation. So both the things are completely collateral with each other. This pledge and hypothecation. Hypothecation is basically, it is called mortgage of some property. So now we will discuss the another aspect of this special contract, that is called contract of agency. It is specifically based from section 182 up to section up to 238 of Indian Contract Act. It is based on principle of law of agency. So this is otherwise called, so who is called agent? Agent is a person who is working for the principal. That means whatever the duty attributed to the agent will work within the scope and ambit of the whatever the work that is delegated by the principal. So definitely the principal is the main party and he is used to recruit the agents. So agents are working under the direction and guidance of the principal. So any deception or any fraud that is taken by this done by this agent, definitely the principal will be vicariously liable for the action committed by the agent. So agents are mainly recruited by principals. So let us, for example, Life Insurance Corporation. In Life Insurance Corporation, many agents are working. So LIC is vicariously responsible and liable under law if anything, any mistake or fraud is committed by their agent. So this is the relationship of this principal and agent. So this, for this creation of agency, express agreement or implied agreement may be there. In certain cases, express agreements, the agreements are made in pen and papers and the terms and conditions are enumerated therein, and the parties, they entered into contract. Those type of contracts are called express contracts. But sometimes by the action of the parties, without any writing, the parties entered into a contract. Suppose a agent is acting for the principal, but there is no documentation, nothing is there. But from his job, it is implied that he is working for that particular principal. So it is implied contract. So it is one kind of implied agency. So there is agency is created. It is created either by express method or also by implied method. So express agency is also there, implied agency is there. So once the agent is doing something and that has been confirmed by the principal, it is said that ratification by the principal. Once the principal is admitting that after the creation of agency or after performance of job, if the principal is accepting the same to be his own direction, then he is called ratifying. So once he is ratifying, it is called by ratification. So the ratification may be either express or implied. So or by sometimes also by operation of law, a contract is done also. This agency is also done by the agent. So different methods are there for creation of this contract of this agency. So there is once there is a formation of agency between the principal and agent, so it is based on the entire contract of agency. So definitely in this type of agency, always the principal is held responsible. The responsibility may be either vicarious or it may be extensive responsibility. In case of vicarious responsibility, that means suppose in case of any motor accident case, in that case suppose somebody died. In that case, the owner is vicariously responsible as far the this quantum or the this compensation is concerned. Suppose a tribunal who is deciding the motor accident cases, motor accident claims tribunal, whatever the money that is awarded by the tribunal, that is called one of the responsibility or fixation of liability on the principal. So, principal is vicariously liable for the action of his driver. But in case of any accident that is happening place, so the driver himself is responsible as per the penal provision of law. In that case, the fixation of liability cannot be shifted to owner or employer. So, in that case, the personal liability will be attributed to the driver for causing rash and negligent driving or anything is done which is knowingly or unknowingly, whatever the case may be. So, penal liability will be imposed on the driver. So, at that time, the vicarious liability cannot be imposed on the principal or employer. So, in this way, these are different types of agency that is created under law. Sometimes you must have seen agents, they used to recruit sub-agents. So, what is the liability and responsibility towards each other? Let us discuss. First, suppose sometimes when in busy schedule, the agents, they used to recruit some sub-agent. So, there is a relationship between agent and sub-agent. So, any sub-agent, suppose working in the field, for his action, the agent will be held responsible because he is the immediate employer. At the end, for any mistake or any committed or any fraud that is committed by sub-agent, the employer or principal employer cannot be held responsible because he do not know that sub-agent, because there is no relationship or agency between the principal employer and the sub-agent. But his relationship is attributed to agent, the person who has employed him. So, agent is directly responsible for anything done by the sub-agent. At that time, vicarious liability also may be fastened on the agent. So, certain rights and duties are also casted on each other. So, once a agent is recruited by the principal or employer, what are the rights? The rights of the agent, whatever he is doing, the principal has got right to inspect, whatever doing he can supervise. So, certain rights are available under law to the principal. Similarly, what are the duties? Whatever the agent has done, he is entitled for commission. The commission should be paid in proper time. So, once the commission is not paid, there is a default. So, certain duties are also imposed on the principal. So, principal and the agent, their relationship is collateral with each other, and their relationship and rights and duties are binding on each other, and all these duties, rights, all these things are binding between the parties, are governed under this contract of agency. So, these are some of the special type of contracts. So, in case of this guarantee and the indemnity and this bailment and pledge, all these things are interlinked, and these are just act like a special formation of contract. That is why all these are categorized under the part 2 of Indian contract, that is called special contract. So, in case of this pledge and bailment, in case of bailment, the properties, whatever the movable goods that is pledged by the pledger with the pledgee. So, in case of this pledge, in case of bailment, whatever the goods that is movable goods that is given for any specified job, once the job is fulfilled, automatically the pledgee is entitled to get back the same in which condition he has delivered. So, certain responsibility and duty are cast each other in all cases. In case of bailment and pledge, certain duties are cast on each other, bailer and bailee. Similarly, in case of contract of agency, certain duties are cast on the principal employer as well as the agent. So, agent is indirectly liable for any action committed by the agent. The vicarious liability goes to the principal employer. So, these are some of the basic laws of this Special Contract Act, and the rest the person that is also evident, and that is given under the law of partnership. We will discuss the law of partnership in our next video, so that the entire this special contract is completed. With this, I am closing the contract part 1 and part 2, general principle of contract as well as special contract. The rest portion we will discuss in our law of partnership, because that portion has been omitted from this, that has been given a separate act.